South Dakota takes one of the most hands-off approaches to rent regulation in the entire country. And if you manage rental property here, you have virtually complete freedom to set and adjust your pricing. The governing law is found in South Dakota Codified Laws, Chapter 4332, and the framework is minimal by design, reflecting the state's philosophy of limited government and maximum property rights. South Dakota does not have rent control or rent stabilization of any kind. There is no state statute that limits how much a landlord can increase rent, restricts the frequency of increases, or requires any government notification or approval before implementing a rent change. South Dakota's regulatory environment is among the lightest in the nation when it comes to rental pricing. South Dakota has not enacted a specific preemption statute prohibiting local rent control, but this is largely because the issue has never gained enough traction to require one. No South Dakota municipality has enacted or seriously considered local rent control, and the state's political climate makes such legislation extremely unlikely. The combination of a small, dispersed population, a generally affordable housing market, and a conservative regulatory philosophy means that rent control is simply not part of the political conversation in South Dakota. For month-to-month tenancies, the landlord can raise the rent by providing advance written notice. South Dakota requires at least one full calendar month's notice before the termination or modification of a month-to-month tenancy. This means that a rent increase, which is a modification of the tenancy terms, requires at least 1 month's notice before the next rental period. So, if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver written notice before April 1st. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. South Dakota doesn't prescribe a specific statutory form for rent increase notices, but a clear, written notice delivered by a verifiable method is always the best practice. Personal delivery, certified mail, or posting and mailing are all reasonable delivery methods. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. This is standard. Without a contractual provision permitting adjustments during the term, the landlord must wait until the lease expires to propose a new rent amount. South Dakota courts enforce lease terms as written, so if the lease is silent on midterm increases, the landlord is bound by the original rent for the full term. When a fixed-term lease is approaching expiration, the landlord should communicate the proposed new rent well in advance. While there's no specific statutory notice period for rent increases at the time of lease renewal, because you're essentially offering a new lease at a new rate, providing adequate notice allows the tenant to make an informed decision. If the tenant doesn't agree to the new rate, the lease expires and the tenant either vacates or the parties negotiate further. For week-to-week tenancies, the notice period for rent changes follows the general one rental period rule, so 7 days notice before the end of the weekly rental period. Now let's cover the restrictions that exist even in this permissive environment. Rent increases cannot be retaliatory. South Dakota doesn't have a detailed anti-retaliation statute with specific presumption periods and enumerated protected activities the way some states do. However, courts recognize the common law principle that a landlord cannot use a rent increase as punishment for a tenant exercising their legal rights. If a tenant reports a health or safety violation to a government agency, makes a good faith habitability complaint, or exercises any other legal right, and the landlord responds with a dramatic rent increase, the tenant may have grounds to challenge the increase. The practical challenge for tenants in South Dakota is that the burden of proving retaliation is heavier without a statutory presumption. In states with anti-retaliation statutes, adverse action within a specified period after a tenant's protected activity creates a presumption that the action was retaliatory. In South Dakota, the tenant would need to prove retaliation based on the totality of the circumstances, the timing, the magnitude of the increase, the landlord's treatment of similarly situated tenants, and any other evidence of retaliatory intent. For landlords, this means that while the legal exposure for retaliatory rent increases is lower in South Dakota than in states with strong anti-retaliation statutes, it's not zero. A rent increase that is clearly timed to punish a tenant for exercising their rights can still result in legal consequences. The best practice remains the same. Document your business reasons for each increase and apply increases consistently across comparable units. Rent increases cannot be discriminatory. Under the Federal Fair Housing Act and South Dakota's Human Relations Act, found in South Dakota Codified Laws Chapter 20-13, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. The South Dakota Division of Human Rights investigates complaints and can take enforcement action. South Dakota's fair housing protections align closely with the Federal Fair Housing Act and do not include the additional categories, like source of income or sexual orientation, that some states have added. However, the core protections are fully enforceable, and a landlord who raises rent in a discriminatory manner faces the same federal liability that exists in every state. Consistency is the key protection against discrimination claims. Apply the same criteria and justification for rent increases across all comparable units. Don't raise rent differently for tenants based on any characteristic other than legitimate business factors like market conditions, unit condition, and operating costs. From a practical standpoint, South Dakota's rental market is relatively small and varies significantly between its population centers and rural areas. Sioux Falls, the state's largest city, has the most active rental market and has experienced steady growth driven by healthcare, financial services, and manufacturing employment. Rents in Sioux Falls have increased consistently in recent years, reflecting strong demand and population growth. Landlords in Sioux Falls typically have good pricing power and can implement regular annual increases. Rapid City, the state's second-largest city and the gateway to the Black Hills, has a different market dynamic. Tourism, Ellsworth Air Force Base, and regional healthcare drive rental demand. The military population at Ellsworth means that a portion of the rental market is influenced by basic allowance for housing rates, which affects how much service members can pay for rent. Landlords near Ellsworth should be aware of BAH rate changes when planning rent increases, as military tenants' housing budgets are directly tied to these rates. Aberdeen, Brookings, Vermilion, and other smaller cities each have their own dynamics, often influenced by educational institutions or regional employers. Brookings, home to South Dakota State University, and Vermilion, home to the University of South Dakota, have student-driven rental markets where demand follows the academic calendar and rent adjustments typically occur at the beginning of each lease cycle. Western South Dakota, particularly the communities near the Bakken Oil Formation and the Black Hills, experienced significant rental market volatility during the energy boom. During peak production periods, rents in some communities increased dramatically as workers flooded into the area. As production stabilized, the market normalized. Landlords in energy-dependent communities should be prepared for cyclical demand that can affect both rent levels and vacancy rates. Rural South Dakota has softer rental markets where large rent increases can be counterproductive. In communities where the population is stable or declining and tenants have options, aggressive pricing can lead to vacancies that cost more than the additional revenue the increase would have generated. Understanding your local market dynamics is critical for making good pricing decisions. One best practice for South Dakota landlords, even though the state has minimal regulatory requirements, approach rent increases as strategic business decisions. Research comparable rents in your area, track your operating costs, and time increases to coincide with lease renewals when tenants are already making decisions about their housing. A well-timed, well-justified increase is more likely to be accepted by tenants and less likely to cause turnover. Another best practice, for properties in competitive markets like Sioux Falls, consider implementing smaller, more frequent annual increases rather than larger, less frequent jumps. A 3 to 5% annual increase is often better absorbed by tenants than a 10 to 15% increase every 2 or 3 years. Gradual increases keep your rent closer to market rates at all times and reduce the sticker shock that leads to tenant departures. For landlords with properties near military installations, understanding the BAH rate cycle is important. BAH rates are adjusted annually, typically announced in December and effective in January, and service members' housing budgets change accordingly. Timing your rent increases to align with BAH rate changes ensures that your pricing reflects what military tenants can afford and reduces the risk of losing military tenants to competitors who price more competitively relative to the allowance. South Dakota requires landlords to return the security deposit within 2 weeks of the tenant vacating, or within 45 days if there are deductions for damage. While this doesn't directly regulate rent increases, landlords should be aware that increasing rent does not automatically entitle them to collect a larger security deposit from an existing tenant. The deposit amount is set at the beginning of the tenancy, and any change would need to be negotiated with the tenant as part of a new agreement. For the complete guide to South Dakota rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.